I know that you not only represent U.S. companies, but also you're very active in insurance and reinsurance business in the UK, in other European countries, in Japan. I'm really curious to know whether for you there are any significant differences in terms of doing arbitration work internationally and mainly maybe in different parts of the world, in Japan and Europe, versus doing arbitration work in the US.
So yes, I mean it is a far more homogeneous world, I would say, than when I started 23 or 24 years ago, and which makes things easier in some respects. There's much higher level of common understanding, which is informed by all of us working together and working with multinational companies, which all of us do. But having said so, there are some significant cultural differences, and the primary one I would highlight, which I adverted to a little bit earlier, has to do with the way these matters play out procedurally. And principally, I would say here in the United States, the cultural overlay to arbitration in particular is really quite dense and nuanced. That it would be very difficult, for example, for a lawyer who is not very familiar with U.S. practices to walk into a U.S. insurance or reinsurance arbitration, because so much goes unsaid and so much is understood by all the professionals in the room before they walk into the room, including and especially the arbitration panel. One such item, which I know we'll get into later, actually has to do with confidentiality. In other countries, I would say the practice tends to be more code-like, better codified, more clear. So for example, the model rules of professional conduct tend to be very important in many of the other jurisdictions where I've practiced. And so the debates, discussions, arguments over procedure tend to be pegged more to that kind of a pole star, and therefore are more predictable and sort of easier to understand that way. The other cultural differences that are worth noting, however, involve the way arbitration panels function. So, for example, here in the States, we run a system where each arbitrator is a party appointed by a party. They are allowed by our ethical rules to commence those proceedings with what the ethical rules term a partisan predisposition. So they're allowed to receive a description of the matter from the party appointing them and commence their work on a case with the presumptive belief that the party who appointed them is right, and to advocate for that party. The only mitigating requirement, which is an important one, is that they do have to listen with an open mind to the evidence, and if they change their minds along the way, they have to vote in accordance with the evidence as they've received it. The umpire is the only true neutral on a U.S. arbitration panel, and there's no communication permitted with the umpire on an ex parte basis. In most other countries where I've worked, the arbitration panel functions as a panel of true neutrals, where there's an individual arbitrator functioning as a single neutral. And so it's the quality of the interactions is really refracted by that difference in some very significant ways, as you would expect. And in those other countries, you really are dealing with a panel of judges, and those judges may be retired jurists, those judges may be retired, active or retired industry people in a particular industry. Your professors, absolutely, or other lawyers, in fact. But the parties' dealings with them are quite different. They tend to be more formal because there are no ex parte interactions, and so it functions much more like a judicial proceeding. So that's another major difference, and there are a couple of others. One is experts. I know I've served as an expert in a few proceedings that have taken place in London, and the rules require experts to confer with each other and eliminate areas of agreement or immaterial disagreement, so that the expert reports and testimony really only focus on significant disagreements. We don't do any of that in the States. The experts each say what they want to say, whether it's efficient or not, and they're examined accordingly.
Do you think when we have an industry arbitration and the arbitrators actually, they represent the parties except for the chairman. Does this somehow undermine the nature of arbitration when we tend to see it as a more neutral platform for dispute resolution?
Well, I don't think it does. I think the principal value of industry arbitration is to invoke the expertise of arbitrators who understand the subject matter of the dispute because they're specialists or have been specialists throughout their careers in that area. And so I don't think that principal purpose of arbitration is undermined by the system.
Mm-hmm.
I do think that arbitration panels here operate quite differently, and I think you're right, or at least the spirit of your question has it right, that the advocacy portion of an arbitrator's role in the United States does in certain respects affect the way the proceeding runs. That arbitrators are expected by the parties, by the umpire, to be advocates at least to a certain measure.
Mm-hmm.
Now again, they're ethically bound if they hear something that undermines their advocacy or causes them to vote no or yes on a particular issue in a way that may be at odds with the party, the interests of the party that appointed them. So be it, they're required to do that. But certainly they're expected to be advocates in ways that they're not in a neutral panel system that other countries run. I should have said this earlier. There are some U.S. panels, some types of U.S. panels, which are expected to function as neutral panels. The AAA rules, for example, do provide for neutral panels, so I should have clarified that.
Right. Confidentiality in insurance and reinsurance arbitration has its peculiarities. Can you talk more about these features of reinsurance and reinsurance arbitration?
Absolutely. Well, you mentioned a moment ago sort of the fundamental purposes of industry arbitration. For many years here in the United States, one of those fundamental benefits, if not purposes, has been confidentiality. And so for the first decade to decade and a half of my career, the working assumption in insurance, reinsurance, and certain other commercial types of arbitration was that the proceedings will be confidential.
Mm-hmm.
The fact of the dispute will be confidential. Certainly the content of documents created during the arbitration will be confidential. The issues in dispute will be confidential, as will the outcome, unless there's an opportunity and a right to confirm the arbitration award in court, in which case a very modest number of facts related to the dispute will become public because they'll be confirmed in court. So that was the working assumption. Some 5 to 10 years ago, various parties woke up and read their contracts and realized that confidentiality really is a customary attribute, typically of U.S. arbitration. So most of the arbitration clauses I've seen over the years in this country do not provide for confidentiality. Mm-hmm. And so parties were, again, as part of the cultural fiber of these arbitrations, were assuming confidentiality and assuming, to use a very American expression, that our dirty laundry would not be aired, that we could resolve our dispute without publicizing it. But the ability to argue against confidentiality and insist that, at least in those cases where arbitration clauses don't expressly provide for confidentiality, insist on a public proceeding has become a tactical weapon of sorts. And U.S. arbitration panels have struggled over the last 5 to 10 years over the question whether they possess the power to impose confidentiality on a proceeding when one party wants it and the other one doesn't. Mm-hmm. And so that is, you've put your finger, I think, on very much a hot button issue in the world of U.S. arbitration right now. And so it's unclear whether an arbitration panel may impose confidentiality. I've seen them do it. Mm-hmm. I've seen them decline to do it on the grounds that they can't arrogate greater authority to themselves than what the contract provides. And if one party doesn't want confidentiality and it's not spelled out, they won't do it. So right. It's a fascinating issue.
Right. In one of the interviews for Legal 360, you were describing two strategies about working with witnesses. One is to push the witness to disclose some more information, another one to give some more break for the witness to take the time and structure the whole process. Can you tell us more how you choose between those strategies when you work with witnesses?
Sure. Yeah, well, of course, we are ethically bound, as you know, to elicit from witnesses only the truth. And of course, when you say work with witnesses, those would be witnesses on our side of a dispute. I learned after spending some time in the UK system and preparing witnesses there that there are some very strong ethical rules over there. So, for example, for many years, a barrister who was putting a witness on either a trial or an arbitration would not even speak to a witness, would rely on the solicitors to discuss the facts with the witness. The barrister would come in with his own questions, his or her, but back then more his own questions, and ask the witness, who would not know what those questions would be in advance because the barrister would not speak with him or her. And so it's a very hands-off process. It has changed some, although that remains the general rule, but it has changed a little bit over there. Here we're permitted to, and certainly it's the custom and practice, to spend more time and be more specific with witnesses. But what I have found is that it's very important to listen to the witness, to allow the witness to express him or herself, both in terms of facts that are percipient witnesses reporting and opinions and ideas that a more intellectual witness is providing. So someone who's analyzing a contract or describing business practices in a way that's non-factual, to take a step back, to listen to what they have to say, because the reality is that even after 23 or 24 years of doing this, you learn something from every single witness you sit down with. And so it's very important to take the time to back up, to not allow yourself to become jaded, not assume that you can portend, you can predict all of the answers that may be coming in your direction, but to sit back and listen to the witness. And that often materially reshapes the testimony you thought you might be in a position to present.
And the final question, personal one as usual. If you had a dispute, insurance and reinsurance dispute, or maybe a contract dispute, and you had only one dispute resolution mechanism, which mechanism would you choose for your dispute?
Well, that's a great question. I'll give you two answers. One, as I said earlier, is it depends on the nature of the dispute and whether I really want someone simply to read my contract and give me a response, or whether I think there are other extraneous or extra contractual factors that need to be considered. But leaving that to one side, I would say probably arbitration. And the reason for that, which is really also the reason I believe culturally arbitration has remained so appealing and such an important history of dispute, such an important part of the history of dispute resolution here in the United States and across the world, is that parties feel that they have a greater measure of control in arbitration. And the reason for that is that they participate in some way, and it's different in every country and under the rules of every different trade association, but they participated in some way in selecting their judges. And if you think about that, if you sort of compare that to totalitarian regimes or even the court system here in the United States and in other countries, that is an extraordinary notion, that you have a hand in selecting your judges, and that the authority those judges, those arbitrator judges wield, emanates from you, from the party, from the two parties. And so that notion imbues the parties with a notion that they maintain a measure of control over the resolution of their private dispute. And I think over the years, my clients and other litigants, other parties to arbitration, have found that enormously appealing, and so that is the method I would select for that reason.
David, thank you so much. This was a great conversation that we had. I think it'll be probably one of the most watched videos. So thank you for joining us.
Thank you, sir, very much for having me. I really appreciate it.
Thank you.